Okay, great. Hi, everyone. Thank you all for joining us today. My name is Rachel Goldenberg, and I'm a lawyer here at Goulart Workplace Lawyers. Welcome to Goulart Workplace Business Cafe 3 and 30. The idea of this session is to tackle 3 relevant topics in 30 minutes. We've left some time at the end if you have questions, so if there's any questions throughout, please feel free to enter them into the chat function, and we'll try and get to as many as we can at the end of the presentation. Today's theme for the presentation is reopening and returning to the workplace.
Sorry, everyone. I've just realized I need to actually set the PowerPoint presentation so that it's going to show like a proper PowerPoint presentation. So as Rachel mentioned, we are here today to give you this presentation, and we're really looking forward to talking about the theme today, which is returning to the workplace. I'm Jennifer Philpott. I'm an associate lawyer with Goulart Workplace Lawyers, and I think more of you are familiar with Rachel as well. So our agenda for today is as follows. We're going to be discussing vaccination policies, remote workplace policies, calling employees back to the workplace from IDL and layoff.
So we're going to start with vaccination policies. As I'm sure you can imagine, we've been getting an influx of questions from a lot of our clients about, vaccination in the workplace and what we can and cannot do. Some of the more common questions are, can companies make vaccinations mandatory? Can they collect vaccination records? And also, what happens when part of your workforce is fully vaccinated? Can you loosen any restrictions? So in our view, a comprehensive vaccination policy is going to be key in addressing these issues and navigating the months and possibly years to come. So I'm going to take some time today to go through some of the key elements that we recommend for a vaccination policy. So we think that all vaccination policies should start with, with a statement encouraging voluntary vaccinations, confirming that the approved vaccinations in Canada are safe and effective. And some employers have also decided to offer some incentives for, voluntary early vaccinations. This can include, some paid time off, maybe in excess of what's being offered in the Employment Standards Act. Or, in the States, they've, been a little bit more extreme about the incentives that they're offering for vaccinations. They've gone so far as to offer monetary incentives and, lotteries to win a car. But I don't think here in Ontario we're quite there yet. I think that's specifically to deal with some major vaccine hesitancy that they have. But, some organizations are comfortable and are choosing to provide some minor incentives just to get as much as their workplace vaccinated as possible. And I think it would be appropriate to incorporate those, into that section of the policy. One of the more common questions that we've been receiving is, can we go further than encouraging vaccination? Can we make vaccination mandatory for the workplace? So the Occupational Health and Safety Act has said that that employers have an obligation to take all reasonable precautions to ensure the health and safety of their workers. So some have taken the position that this kind of overarching obligation, allows them to make mandatory vaccinations because they are necessary to protect the workers in their workplace. So this is particularly appropriate when, they might have a lot of employees working in close proximity to each other, for example, warehouses, or when the workforce is working closely with or includes members of a particularly vulnerable population. In those circumstances, the vaccination against COVID-19 is being declared an essential condition of employment and therefore mandatory to be employed. So if this is going to happen, there's 2 things that we think are important. The first is that this condition of employment should be added to all future employment contracts. So whenever you're hiring a new employee, it's going to be clear that it is an essential condition of their employment that they are vaccinated against COVID-19. For existing employees, right, you're not going to, who already have a contract, it's going to be important to incorporate this into the vaccination policies. So basically, the policy would go further than just encouraging vaccination, and it would say that vaccination is an essential condition of employment and is mandatory by a specific date. The date that you put in the policy is going to be based on availability. As of right now, the government is saying that all adults should be able to be fully vaccinated by September of this year. So in light of that, a mandatory vaccination deadline of the end of September might be an appropriate place to start. Of course, that might be subject to change if availability changes. We've seen just this week with the delayed Pfizer shipment, we're not out of the woods yet. So that might have to be a little bit flexible if vaccine availability changes. We also think it's important for a policy to specifically state that you're required to obtain an approved vaccine, or a vaccine that's been approved by Health Canada, because as you know, there's a number of vaccines available globally in the world. As of now, Canada has approved 4 of them: Moderna, Pfizer, Johnson & Johnson, and AstraZeneca. But there are others like the Russian vaccine and that haven't yet been approved. So the policy should kind of, it's not just any vaccine, but an approved one. And it should also mention that it's going to be a requirement to obtain or to comply with the recommended vaccine schedule. And, this may involve boosters down the line. So, having said that, some employers may be able to require mandatory vaccination, without clear legislation, it is unlikely that employers will be able to force their employees to actually physically take the shot. So companies are going to have to be prepared to deal with situations and implement measures in the event that someone cannot or will not be vaccinated. And that's going to be important to incorporate into your policies, whether you're just encouraging voluntary vaccinations or you're implementing mandatory vaccinations. So the first section, or the first situation you're going to have to address or deal with, is what if an employer cannot be vaccinated for a genuine medical reason? So in that case, medical conditions are protected under the Human Rights Code, and the employer will have a duty to accommodate the employee to the point of undue hardship. So appropriate accommodation might include, that employee who cannot be vaccinated continues to wear PPE, perhaps has modified work duties where they're not in close proximity to other lawyers, perhaps has continued remote work, and it may even include a leave of absence if that's the only alternative. There has been talk about what if someone requests a religious accommodation and says that they cannot be vaccinated on religious grounds, because religion is also protected ground of Human Rights Code. But the Human Rights Commission has made a statement that a personal belief against vaccination is not protected under creed or religion. So it's only going to be established religions that are, against vaccinations that will be covered. And I think this is going to be a lot less common than the medical, the medical situations, or the situations where someone just has a personal belief against vaccinations. So the next situation that the policy should deal with is, what if employees choose not to vaccinate? So as I mentioned, the Human Rights Commission has confirmed that this is not a protected ground. So therefore, technically, there's no obligation to accommodate these employees, right? Despite this, in most situations, an employer could undertake to find non-disciplinary alternatives to vaccinations, right? So it's not going to be an obligation to accommodate, but they can, the policy can say, where possible, we will undertake to find a non-disciplinary alternative to vaccination. And some of those might look similar to what you would do for an accommodated employee, like continued PPE or modifying their work duties. However, even if you are going to implement a non-disciplinary alternative, all policies should reserve the right to take any necessary measures to protect your workforce against non-vaccinated employees. And this will include implementing a leave of absence or ultimately ending the employment relationship. So this will allow you, if you have an employee who refuses to be vaccinated and it's for a non-medical reason, you know, you can try and implement alternatives, have them continue PPE, maybe put them in a separate workspace if that's feasible. But at the end of the day, if, you know, you will reserve your right to get them out of the physical workplace if that's what you need to do for the protection of your other employees. So we know, and we've already had some discussions with clients about, you know, employers who kind of want to take a strong position against those who just choose not to be vaccinated for personal reasons and not medical ones. And they don't want to consider any alternatives. They want to just say, look, we're implementing mandatory vaccinations by a certain deadline. If you are not vaccinated by that day, we are going to end the employment relationship. So there hasn't been cases that have litigated this yet, but in the legal community, it's our belief that, you know, failing to vaccinate because of a personal belief, it's not going to be cause for termination. That means, you know, if someone refuses to comply with a mandatory vaccination deadline, you can't let them go without a package. You're probably going to have to package them out. And if that situation happens and you want to talk about that for a specific employee, we would be happy to explore that with you. One of the last sections of the vaccination policy will be to address getting proof of vaccinations. So an employee's medical information, including their vaccination status, is generally considered private and confidential. However, an employer could have the right to that information when they need it for a bona fide occupational reason. In the pandemic, employers have a genuine reason for wanting this information, right? So employers can collect vaccination records or information about vaccination status. The issue is that employers will have to take all reasonable precautions to protect that information and to maintain it in a secure and confidential manner. So this may include having, you know, one designated person obtain and hold and store this information. What's also really important is that because vaccination status is personal health information, an employer cannot share their employee's vaccination status without the consent of that employee. So, you know, this may include advertising that your workforce is 100% vaccinated. Unless you have the consent of your employees, you can't really release that information. The last thing that we recommend a vaccine policy includes is, you know, what happens post-vaccine. Right now, public health guidelines haven't changed for fully vaccinated employees, but we anticipate that this will happen. So as of now, we're recommending it just includes a section that says any fully vaccinated employee has to continue complying with all public health guidelines until they are released. And yeah, obviously these policies are going to have to be tailored for the organization. We have, you know, we've been working on these policies with a number of our clients, and we're happy to work with you as well.
Thanks very much, Rachel. So now we're going to turn to the discussion of remote work policies. And several of you, or many of you, may have actually had these policies in place around this time last year, or maybe even a bit earlier, when employees started to work remotely. Some of you may not have adopted these policies, but they're nevertheless in effect. So maybe not written, but through the work that's been done since the beginning of the pandemic, your workforce might be operating remotely, although there's no concrete policy in place. And so you may be wondering if it's time to move to making this a more permanent model, or some of you might even be considering hybrid models as well. And so we're going to outline some of the key considerations that should come to be part of the discussion when you're considering either revising and moving forward with your existing remote work policy, or implementing one for the first time. And of course, if you have any concerns about this, you can contact our office and we'd be happy to help you revise an existing policy or implement a new remote work policy. So the first point that should be considered is who is eligible for remote work. And when you're thinking about this, it's important to define expressly in the policy the specific positions that are eligible for remote work. So certain positions will lend themselves to doing this work not outside of the office. So you don't necessarily need to be with your teammates, your colleagues. You might be able to have a remote desktop situation, as opposed to other positions that require individuals to physically be at work. However, another consideration that goes into defining who is eligible for work is the actual matter of performance. So, for example, you might want to consider making satisfactory performance a condition of that eligibility. And if any performance issues arise ongoing, then the employer should be able to reserve the right to recall the employee to work. And this can be built into the policy expressly. Next, you would like to define the expectations for working outside of the office. So this is a pretty broad topic and includes some very important considerations, some of which, for example, could be setting hours and work schedules so that employees aren't working at strange hours of the day. If typically in the office, the normal traditional workday would be a 9 to 5, you would want to set that out expressly in the policy as well and deal with a provision that addresses overtime and make sure that you've noted down the parameters of how overtime will work. So how is it to be claimed by the employee? What documents do they have to submit? How will approval work? And this is very important because many employees have been working overtime or abnormal hours during the pandemic. And so putting in those clear parameters will help clarify any ambiguity about that. You also may want to include provisions about the timelines for the completion of work, as well as how employees should communicate with each other or how they should communicate with management. If there is going to be certain platforms used that are acceptable. For example, we're hosting this webinar on Zoom. Some offices have chosen to make Microsoft Teams their default software device in order to host meetings and discuss confidential matters, which we'll also touch on. And another important consideration that would go under defining expectations is compliance with existing workplace policies. So the things that come to mind, for example, would be health and safety policies and any other human rights policies that might be in the workplace as well. You want to make sure that your staff and your workforce are carrying out those protocols in an adapted way while working remotely. And so those policies may also need to be updated and revised to take into consideration that workers are not always going to be in the office. The next in consideration to keep in mind is the plan to protect your confidential information. So in many of your workforces, you may come into contact with sensitive information in a soft format, so digital Word documents, PDFs, things of that nature that you want to have safely stored. So if you haven't considered already, you may wish to consider implementing a remote desktop with two-factor identification that requires members of the workforce to log in multiple times with maybe different passcodes in order to protect that information. Using passwords as well can also be useful to protect soft copy information, and making sure that passwords exist for things like Zoom meetings or Microsoft Teams meetings as well. For hard copy materials, you may wish to consider putting policies in place that require employees to keep hard copies of printed materials in safe locations. And, I'm just going to admit someone to the room. Sorry, everyone. There we go. So keeping hard copies stored safely as well, that's also important. because those documents could be loose. Some employees might want to print from home as well. So how are you going to go about the maintenance of those hard copy documents? Will employees be required to shred materials on a case-by-case basis or in a certain period of time? And lastly, with protecting confidential information, you want to think about where employees are working. So yes, employees are working remotely, working from home, but you may wish to outline in the policy that certain workplaces are not considered appropriate. So defining the workplace that is suitable to the type of work that you do and considering the privacy requirements involved if you're having confidential phone calls or dealing with confidential information on the go. For example, an employee might be able to work remotely, but that shouldn't be necessarily at a cafe or in a restaurant or outside in a public space, given the nature of their work. So these are all important considerations to take into account. Some other considerations that you will want to consider are costs. So how are expenses going to be reimbursed, if any? Perhaps some of your employees have already spoken to you about printing from home, getting reimbursed for stationery, potentially for hard equipment like laptops and printers, or other ergonomic devices to do their work that they once did in the office from home, or loaning that equipment from the workplace as well. It's important to categorize those expenses and set limits as to what will be reasonable expenditures for employees. You'll also want to consider the ability of the employer to recall and compel the remote worker back to the office. So there should be a provision in the policy that enables the employer to reserve and preserve this right. And generally what's best practice is to give the worker some notice that they'll be called back to work within a reasonable period of time. And that might look different for different workplaces and different situations, but within at least a week's notice is generally considered reasonable, and that they know in advance that the employer could give them a heads up of that duration, that they'll have to return to the physical environment. And lastly, the duration of the remote work environment. You'll want to consider setting dates for periodic review and ensuring that the employer retains the right to do that on a regular basis. This gives the employer flexibility to review the policy and make changes as needed. And flexibility, as we all know, is something that's become incredibly important to employers and workplaces as we navigate the ever-changing nature of the COVID-19 pandemic. And so building in these safeguards is very important so that employers and management retain these rights and can adapt on an as-needed basis to ensure that their staff are functioning adequately in the remote environment and that business is continuing on as expected. And so now Rachel and I are going to both discuss calling employees back to work following the infectious disease emergency leave and some considerations.
Thanks so much, Jen. So yeah, now we're going to talk about the infectious disease emergency leave. So at various points during the pandemic, employers had to make a lot of difficult decisions. And for many, this included laying off portions of their workforce or reducing their hours because of the pandemic and the resulting business closures. So in March 2020, the Ontario government introduced the Infectious Disease Emergency Leave regulation. And so this deemed any employee whose hours or wages were reduced because of COVID-19 to be on a leave rather than a layoff. So this leave has been extended numerous times, and most recently it's been extended to September 25th, 2021, when it's set to expire. It really is hard to anticipate if it will actually expire on that date, given how many extensions there have been. Given the vaccination rates and the situation right now, we think there is a very real possibility that it will expire on September 25th. So this is something that all employers who may have employees still on leave will have to be really mindful of, because if that date hits and the leave is over, and you've done nothing in terms of recalling them back or extending it, that's most likely going to be a deemed termination, and some termination payments are going to become due. So, but as the province is reopening, even prior to this September date, a lot of companies are already in the position to return people from their leaves. So I'm going to quickly take you through what would be involved in this process. So the first step is going to be preparing a written recall notice for these employees that are currently on leave. This is going to be similar to a recall notice, recalling people from layoffs, if you've ever had experience with that, but there's going to be a few added pieces. So, an ordinary recall notice will just say, the date that they're going to be recalled. You do want to try and give some advance notice, where appropriate, but it's just going to give them a date that they're going to be expected back in the office. It's important that with these recall notice, especially if you're recalling them prior to September 25th, 2021, that you note that this is going to be, it may require some flexibility and it may be subject to change based on the situation with the province. As we know, our case numbers and our public health rules, saying which businesses can and cannot open can change very, very fast. So you're going to want to reserve the right to make any necessary changes. This letter should also detail the processes in place for returning people back to work. Some of these individuals may have been on leave for a good portion of the pandemic, just simply because the business has been closed for a good portion of it. So there's going to be a lot of public health measures in place that they may not have a lot of experience with, and laying that out either in the notice or as an attachment will really help with this transition. The second step in recalling people to work is going to make sure that you develop and implement the appropriate policies. So this can include two of the policies we've just talked about, the vaccination policy and the remote work policy, if that's going to be applicable. But also companies may want to consider doing a review and updating just their overall health and safety policies, given that the pandemic, still is a reality and poses health and safety risks. I think next Jen is going to talk about, recalling people from the leave and how that can impact potential constructive dismissal.
Yes, so several of you may already be aware from either our newsletter or from other sources that there have been two decisions out of the Superior Court of Justice of Ontario in the last several months addressing this issue of constructive dismissal at common law and whether the IDEL constitutes constructive dismissal at the common law. The first decision that came out is Contino and Ocular Health Center. And in that case, the court held that an employee who was placed on a temporary layoff due to the COVID-19 pandemic was deemed to be on IDEL was constructively dismissed at common law. So this decision was the first that we had heard of from the courts addressing the implications of the regulation addressing IDEL. And the following decision, Taylor and Hanley Hospitality, which is more recent, held that the government enacted regulation that created IDEL displaced the common law, and that a temporary layoff did not constitute constructive dismissal under either the Employment Standards Act or constructive dismissal at the common law. So this decision, Taylor decision, directly referred to Contino decision as well, and said that the interpretation in Contino rendered IDEL meaningless and offended the rules of statutory interpretation. And the court went through a lengthy analysis explaining why that decision incorrectly interpreted the matter at hand, and that it failed to appreciate several factors, including the fact that the legislature created the problem itself by triggering the state of emergency and requiring employers to either suspend or cease operations, and then causing employers to lay off their employees or reduce their hours, which then exposed them to claims of constructive dismissal. And that to avoid this consequence, ultimately, the regulation was implemented so the legislature solved the problem that it created. So for the time being, it remains to be seen whether one or either of these decisions will be appealed. We have two conflicting decisions out of the Superior Court, and it is likely that one will be appealed because employment lawyers everywhere are waiting with bated breath to find out how this is going to be resolved so that we can best advise our clients. Right now, employers are likely going to want to rely on the Taylor decision. But that being said, we have to wait and see what the ultimate outcome will be. And in the interim, there are other defenses that might be available to employers, which Rachel will now outline.
Exactly. Thank you, Jen. So yes, because of these conflicting decisions, companies may still experience an influx of these constructive dismissal claims where someone has been placed on the infectious disease emergency leave. So, if that happens, and if you're faced with that claim, you can definitely rely on the Taylor case, but there are also other defenses that are being explored and that can be relied on to protect your organization from ultimately having to pay out, a significant common law package when, you simply place someone on leave because your business was forced to close. So, those defenses are really going to depend on the specific circumstances. And if this comes up, we would be happy to take you through them. But just to give a quick overview, they might include, that you have an express or implied right to lay off. This defense has existed with respect to placing employees on temporary layoffs under the Employment Standards Act long before the pandemic. So if you either have a contract, a policy, or a past practice of laying people off, you can use that, as a defense against a constructive dismissal claim. There's also the concept of condonation. So typically, when you make a material change, whether it's a layoff or a reduction in pay or change in a role, employees have a reasonable amount of time, which in most cases is about 1 or 2 months, to refuse that change or to oppose that change and claim constructive dismissal. If they don't, then it's as if they have condoned it and they can't later come back. So if you place someone on a leave, months and months ago, and they took advantage of the CERB benefits and everything, but when you call them back, they try and say all of a sudden, oh no, this was a constructive dismissal, now I'm entitled to this package. You can say, no, you've condoned the leave, you've been off it for several months, so you can't now claim constructive dismissal. And the last concept is frustration. So this is novel. It hasn't been tested in the courts yet with respect to a COVID-related leave, but basically frustration occurs if the employment contract cannot be performed through no fault of either party. So if the employee is going to be arguing that a leave resulted in the end of the employment relationship, then we can try and argue that the leave was due to COVID, which was no fault of either party. So it's not, a constructive termination, it's a frustration. So this hasn't been tested yet, but it's seriously being contemplated by the legal community. So we'll see where that goes. So I think that's it for our presentation, and we have a few minutes to go through some questions. Some people have been sending us questions in the chat, in the public chat, and we've been getting some direct messages as well.
Yes, we have quite a few questions.
Perfect. So Jen, do you want to start?
Sure. So I'll start reading some of these questions that we've received. So the first question is, in a company that has mixed warehouse and office staff, can the mandatory vaccine policy apply to one group based on job function and not to the rest of the groups? So example, warehouse employees are required to, but accountants, for example, are not.
Mm-hmm. That's a great question. And I think based on, this is a really novel area, so it's hard to have really, any real certain answers. But to answer this question, I would look at what's been happening in mostly the unionized healthcare environment surrounding influenza, like the flu shots. So there are healthcare settings where the flu shot is mandatory for certain healthcare workers that work with particularly vulnerable people, but isn't mandatory for, let's say, the entire hospital, including the administration. So based on that, I think it would be appropriate, right? Because you're going to have to justify for whoever the mandatory vaccination policy is going to apply to. You have to justify that it's an essential condition of their employment. So in that case, I would say that it would be that it would be possible to make that distinction.
Yeah, I agree, Rachel. I think you've hit the nail on the head there. As much as we can know within everything that's changing, and as we're waiting to see how these policies are actually carried out, and if any legal matters are brought up addressing the veracity of them as well.
Mm-hmm.
The next question we have is, if employees are vaccinated, then they're protected against COVID-19, well, to an extent that we know now. And even if a vaccinated person gets COVID, we're being told, again, based on what we know right now, that it might not be as severe as if they were unvaccinated. So how then does an unvaccinated person put a vaccinated person at risk?
Mm-hmm.
This question maybe is a bit more, it definitely has a more scientific in nature element to it. I mean, we're just employment lawyers. We don't necessarily know the outcome of vaccines on individuals' health.
Right.
But looking at it in that context, we can comment.
Yeah, so I think that's a good question. And the fact is, a lot of, the information we're getting from, the scientific community, some of it may not be entirely consistent. I've personally heard different things about the efficacy of the vaccine and what it does. So based on my understanding, from what I understand, it does protect a fully vaccinated person from getting severe symptoms, but it doesn't stop them from being a carrier of the virus. And I think it reduces significantly the rate of transmission, but it doesn't completely eliminate it. So because of that, even if you have an entirely vaccinated workforce, so even if it's spread amongst them, it will not be serious. They may be able to, carry it to someone else in their lives. And I think a lot of us, for a long time to come, we'll have people in our lives that aren't able to be vaccinated. For example, I have young children, and who knows when they'll be able to be vaccinated. So, or there might be people who have family members either that have chosen not to be vaccinated or cannot be vaccinated for medical reasons. So I think the guidelines around, the public health guidelines for people that are fully vaccinated are probably going to take into consideration that potential risk of them carrying it. And, even if it's a mild case, I also personally, if I can avoid even being fully vaccinated, if I can avoid exposure, I would like to. So I think that's what's going to be behind the public health guidelines that are going to remain in effect.
Yes, I think so too. I think we have to think big picture about the fact that, as you said, it reduces transmission. You might not get as sick, but there are still going to be many vulnerable members of our community, and including our colleagues who may not be able to, or may choose not to be vaccinated. And so accommodation has to be taken into consideration there, and also just the unknowns. We don't know the long-term risks of COVID, and how that affects the nervous system or the heart. We don't know so many things. So we have to be careful, and putting those vaccination policies in place might be something that your office is interested in doing. Another question we received has to do with remote work policies. And the question is, can an employer introduce a remote work policy to be signed now after already being remote all this time? So presumably being remote all this time without a policy in place.
Mm-hmm. That's really interesting. Mm-hmm. I think a lot of companies went to remote work at the beginning of this pandemic very fast, just because businesses, had to physically close, and a lot of companies didn't have the time to implement the proper remote work policies, right at the beginning. There was a lot going on, and I think that's understandable. Some companies have, in the interim, started to roll out some remote work policies, but I can see how, not all companies have done that. I think that as long as the remote work has been tied to the pandemic and the public health guidelines and restrictions that were imposed by the pandemic, it's a little bit understandable. So, if as the province is reopening and there's the option of returning to work, if you don't already have a policy, now would be a good time to introduce it, because now it's not just purely because of the pandemic. You're considering a remote work or a hybrid model going into the future. I think it would be important and very possible to introduce one now, even if you haven't had one up to this point.
I agree, and I think that it's a good practice to implement one now, better late than never, in order to solidify and actually lay out the matters that we discussed before and the key considerations that you would like to have going forward, see what worked and what didn't work, and then of course building that flexibility to revisit it, because the situation of remote work as impacted by COVID-19 is ever changing. And so building in the employer's ability and preserving that right to make changes as necessary is crucial.
Right. So I think we have time for one last question.
Okay, I've got a few questions here, so I'm just looking to see.
And if we didn't get to your question today, please feel free to reach out to us at our emails or give us a call, and we'd be happy to chat with you offline.
So the last question we'll take today is also about remote work policies. And the question is, our intention is to have staff back in the office most of the time with some reasonable amount of flexibility for working from home. And reasonable is in quotes. Do you have any suggestions on how to define reasonable and how to set rules and guidelines surrounding this? I think this is a great question because it lends itself to this hybrid model of, being at home part of the time, being in the office for part of the time. And many employers are asking themselves, what is reasonable? And I think in part, this is going to depend on the nature of the workplace and the expectations that the employer has. But certainly on a case-by-case basis, you would have to set out the rules and the guidelines that you think are appropriate, again, based on what you've seen to date, what's worked, what hasn't worked, and take it sort of one step at a time on that basis. But a great question, and I think, Rachel, you might have something to add as well.
Mm-hmm. No, that was right on. And I think that, in terms of defining what's reasonable, there's a couple of options. You can just state in your policy that you will have the ability to, or flexibility to work from home, for a reasonable amount of time, or you can define that as, 1 day a week, 2 days a week with the approval. You can put in requirements and guidelines that work for your specific organization. And, if you want to canvass those with us and talk about what could work, like from a practical perspective, we would be happy to.
Yes, certainly. And I think it's great to be thinking about defining these terms because there has been so much ambiguity. And that's the benefit of, if you haven't put a policy that's written and concrete into practice yet, turning your mind to that now is something to consider, because it's easier if you define these terms rather than leaving them out to be misunderstood or have broad definitions.
Perfect. Well, thank you everyone so much for joining us today. If you have any questions about any of the topics we've discussed or any other topics that we haven't broached about returning to the workplace, we know this is a real live issue for a lot of our clients. So please don't hesitate to reach out from us. We're available by email, phone, LinkedIn, and I think Jen, if you want to also explain that.
Sure.
Clubhouse.
Yes. So while I still have many of you in the chat, I'd love to just quickly explain what Clubhouse is and how you can join us. So Clubhouse is an audio-based app. Think of it like a live podcast or an audio seminar, just like what Rachel and I are doing right now, but with no PowerPoint and no visual component. The app is free to download and make an account. You can join our club, which is Workplace Law. If you search it in the app, you'll be able to find it. And we're having regular sessions on an ongoing basis, one of which is tomorrow night at 7 o'clock. Rajveer Binder and I will be talking about these topics as well and going into more detail. And so if you have any questions that we haven't answered, feel free to join us tomorrow there. I'd also like to let you know that our website has been updated and we now have an events page. And so you can check that out on a regular basis to see what events in Clubhouse and other webinars we might have ongoing. And then hopefully down the road, when it's safe to get together again in person, there might be other events too that we offer. So keep your eyes peeled there. And of course, we will continue to send out regular newsletters with updates and registration links to webinars like this, and also details about other events that might be happening in the future.
Great. Well, thank you, everyone.
Thanks so much. Everyone stay safe and have a great day.